position where the court, in having regard to the sentencing guidelines, where these are inconsistent, when the guidelines from the Sentencing Council are inconsistent with Section 1, that the court need not comply with Section 1. Now, that raises the question, does it not, as to what the principles to be applied by the Scottish Sentencing Council might be in that connection. I wonder if you would elaborate on the point you made.
I think I do have a concern about that. If the principles are to be recognised as principles applicable in the criminal justice system, then the principles should be applicable to the Guidance Council as well, Guidelines Council as well, and it shouldn't be free, as it were, to deal with the matter without regard to these principles.
And I'm conscious of your time, but one final question, if I may, which relates to the issue in Section 24 about alcohol and the question of bereavement, I think, was suggested in your written statement as a possible mitigating factor. It's voluntary intoxication not being a mitigating factor, but would that exclude consideration of the bereavement in the background as being a factor that could be taken account of? In other words, would it be as practically restricting as perhaps you're suggesting in your submission?
Well, if the situation is that there is an absolute prohibition in taking into account the existence of voluntary ingested alcohol, then I don't think the background circumstance that it arose out of a personal tragedy of that sort would allow the sentencer to take that into account. And I can think of other examples as well. I mean, there was the case which gave rise to a lot of controversy quite recently about the young woman who'd been sexually assaulted outside a club of some sort and had driven off when she was affected by alcohol, and ultimately she was prosecuted. And there was an issue as to whether she should have been prosecuted or what the ultimate disposal would be. But if this applies in its terms, then you wouldn't be able to take into account that this young woman had driven off under the influence of alcohol in circumstances in which most people at least would recognise that there was some mitigating factor arising in the circumstances.
Which perhaps is a solitary example of the kind of difficulties you can get into by trying to be too prescriptive in statute about these matters.
Yes, I think that's true.
I'm very grateful. Thank you very much.
You may think that the Lord Justice General cannot possibly say that. Right, Stuart Maxwell.
Just to follow up on Robert Ryan's question, I'm not sure I follow your line of argument. It seems to me that Section 24 talks about the voluntary intoxication, that the voluntarily consumed alcohol, and that the consumption of that alcohol should not be taken into account as a mitigating factor. It does not seem to me to suggest in any way, shape or form that you could not take into account as a mitigating factor other circumstances. For example, the person was recently bereaved or had been sexually assaulted or any other matter. So I'm not sure I follow why because you couldn't take the fact that they were under the influence of alcohol into account, that you couldn't take into account the fact that they had been emotionally disturbed or had acted in a strange way or an abnormal way because of other circumstances.
Well, I mean, I see the argument which you present. It does seem to me that, at least as framed, it gives rise to an ambiguity which ought properly to be addressed.
Surely be that the proximate cause of the intoxication was the traumatic experience which the individual had, and it would be quite competent to introduce that in mitigation.
Well, I'll leave it as a matter for the committee to consider.
Right, we are aware of the time constraints this morning. Lord Justice Clark, is there anything you would wish to add in conclusion?
No, there's nothing I wish to add.
Lord Justice General, anything you would wish to add?
No, I think not, thank you.
Right. I take it that if there are any issues that arise, that you would be quite happy to respond to these in correspondence. Can I thank you very much indeed for your attendance this morning. We do appreciate the pressures, and this has been an exceptionally useful evidence session. Thank you very much indeed.
The committee.
Committee will suspend briefly.